SABC News presentation.
You're watching Interface. My name is Thembi Samachele. Thank you very much for joining us. The verdict in the Oscar Pistorius trial has elicited strong criticism, as I'm sure you've picked up, from many South Africans who believe that the judge was too lenient. Many say the judgment has sent the wrong message about crime, about violence against women, about class and race. Some experts here and abroad have criticized the verdict, and they believe that the prosecution has a strong case for an appeal. But what lessons have we as South Africans learnt about the judicial system, and has our judiciary passed the test? These are just some of the questions that we're posing tonight, and our guests are from our Cape Town studios, Professor Pierre de Vos, who is a constitutional law expert at UCT, and Lisa Vetten, who is an honorary research associate at Wits University. And as always, remember that if you would like to join in this discussion, our Facebook page is always welcome to your thoughts, and you can just drop us a line on there. It's Interface on SABC2, or you can hit us up on Twitter at Thembi Samachele or at Interface on SABC. Welcome to both my guests. Thank you very much for joining us.
Thank you, Thembi.
Prof, let's start with you. We've heard of many criticisms to this judgment, many saying that the judge got it wrong. Is it a case of us as South Africans, the laymen, not understanding the law? Is that what's happened here?
Well, I don't think it's necessarily that lay people didn't understand the law. I think that many academics, many lawyers agree with many of the population out there that something doesn't feel right in the findings of the judgment. Because they say, well, if you're going to shoot 4 bullets into a small space where you know somebody's behind the door, surely you would have the intention, you would have believed that your actions could lead to the death of that person and you had no right to do so. And so, you know, I understand why people are upset. Of course, some of the criticism has gone too far and have made personal attacks on the judge, which is not acceptable. Sure. But it's perfectly acceptable to critique the judgment.
What do you think has led to her conclusions here?
Well, I would be a little bit careful to try and get into the mind of a judge who is actually has 15 years experience and so forth. But when I restudied the judgment again yesterday, what seemed to me very interesting, I almost felt that the judge required too high a standard of proof from the state. Not that the state had to prove its case beyond reasonable doubt, but beyond any doubt. Why she did that, I don't know, but it seems it makes, so I don't really understand. But I think what one has to at the same time say that the law is not a precise science. Reasonable people can differ. She looked at all the evidence, she came to a conclusion. Many of us think it was wrong, but that doesn't mean that the whole system is therefore completely unjust or never works or whatever. I think we must caution against that.
And that's what I want to ask you, Lisa. But there's a quote that I read in one of your articles where you say, the Oscar Pistorius trial is more than an inquiry into the athlete's responsibility for the death of Reeva Steenkamp. It is a window into a larger narrative and politics of gender and race permanently under construction in South Africa. What did you mean by that?
Well, I think this trial did turn on a particular set of gendered norms, and the ones that Oscar Pistorius was trying to utilize were those around man as protector. So in that way, it was slightly different from the typical domestic violence homicide trial, where the gender norms there tend to turn around how awful the woman was. So that's the one leg in which those cases typically go. And then the other component where they also typically go is to suggest that because her behavior was just so outrageous and so provocative, the poor man had some strange emotional mental storm, which meant he didn't really know what happened. And when he came to again, there she was dead. The gun had just gone off in his hand. And the trial didn't do that. It didn't try to blame her for her own death, which I thought was a positive feature of the trial. And so while we might be this decision is contentious, it's not one with specific application to future domestic violence cases necessarily. It will apply to most cases that occur under questionable circumstances of whether or not there was an accident. But I think what this case also does in terms of race is there was, for those who are watching, a whole subtext going on amongst a particular section of the white community around what does Oscar Pistorius' actions say about white men's violence. There was a particular section of white society that wanted to suggest that this case was exceptional. White men hardly ever kill white women. It's chiefly black men who kill white women. So there were at least 3 sets of complaints that focused around that were brought up, I think, by the Oscar Pistorius trial.
And is that the case, though?
No, not at all.
Just getting back to the very judgment and the fact that South Africa, it seems, our judiciary was in the spotlight. We were undergoing some kind of test, some exam. Did we pass?
Look, I think we saw a very good example of the judicial system. We did not get at the norm. I think if you want to see the norm, go and sit in the regional court and the magistrate's court and watch the cases where men have beaten women to death. They haven't even been charged with culpable homicide. They've been charged with assault with intent to cause grievous bodily harm. We're on postponement number 35. The evidence hasn't come to court. We're going to postponement 36. So I think we got probably a better picture than what is traditionally going on. And I think the other thing to put this case in context is that about 70% of intimate femicides actually never result in a conviction. So this case belonged to the minority, the 30% that do actually result in a conviction.
But do you think because this case was so high profile that it will have maybe a positive impact on the other cases that are still to come, that maybe they'll be taken a little bit more seriously or maybe not?
I don't think so. I mean, I think for that to happen, we'd have to try and encourage a greater media scrutiny. And that's my concern about this case, is it's one case. We need to open up and broaden the scope to look at these cases more broadly, if this case is to have any meaning. Otherwise, our attention is going to move on to something else when this case is over.
All right, we have to take a short break. We've got to pay the bills. We are back after this break. Do join us in this discussion by posting on our Facebook page or hitting us up on Twitter. Stay with us. Welcome back. This is Interface. We're talking about the Oscar Pistorius trials and lessons learned from that trial for the South African judicial system and also for us as ordinary South Africans. Do give us your thoughts on what you learned, what you picked up during the course of the trial, and what your thoughts are about the verdict. And as you can imagine, Facebook, Twitter, everything is ablaze. Let's just take just a couple, if you'll allow me to just look at a few coming through on our Facebook page. Marilyn Broughton says, easy to blame the judge, typical South Africans. She is now the target for doing her job. Teb Zatladi says, the law deals with facts, not hearsay. Media influence and popular belief doesn't apply. And Mr. Nell simply failed to prove intent. Denzel Harper says, SA is plagued by shoddy investigative work. Journalists would even do a better screen of any crime scene. Thank you very much. We do take that compliment. Nozuko Nenzani says, money talks. Oscar Pistorius deserves a life sentence. And on and on and on your Facebook messages go. We'll see if we can touch on a few others later on the show. But Prof, let's just get back to you. This particular verdict, the judge said Oscar Pistorius was an unreliable witness. She said that the defense that was offered, there were varying accounts of what they said happened, and yet she still came to this decision. Why do you think that in spite of those issues, she still arrived at this point?
Well, if you read the judgment, she seems to suggest that she believed Mr. Pistorius when he said he was truly fearful. He feared for his life. And the part of the judgment is not so clear, but the second part of the test, that he actually believed that he was justified to shoot somebody behind the door, and that he didn't really think that that action would lead to the killing of the person behind the door. So whether the facts actually show that, I'm not so sure that it does. But that's what the judge believed, that aspect of his testimony. She said, well, many of the things he said didn't make sense, but that doesn't mean if somebody is not truthful about certain things, you have to throw everything he says out of the window. the state, you still have to look at all the evidence, and then beyond reasonable doubt, the state has to prove its case. She just happens to believe certain parts of his testimony about him being fearful, about him believing that he had the right to do what he was doing. And on that basis, he was not convicted of murder, but she found that his belief was clearly unreasonable, and therefore he's convicted of culpable
Two
homicide.
things I'd like to bring up on that. One is, please explain these beautiful Latin terms that we came across, dolus eventualis, dolus directus, or as one person on a radio station said, Dolly Parton. You know, it's all the same. What do those terms mean, in essence?
Yes. When you are charged with murder, the state has to prove that you acted unlawfully and then that you had the intention to kill somebody. So the state has to prove that you actually, subjectively, yourself, not what a reasonable person would do, but what you believed. You believed that you wanted to kill somebody. And that can be proven in two ways. Either it can be shown that you actually really wanted to kill person X, you took out a gun, you pointed at that person, you shot them, or that is dolus, or it can be proven through dolus eventualis. That means you had foreseen that what you were doing could cause the death of person A or another person. You had reconciled yourself to that, and you nevertheless went ahead. You took the action which you foresaw could possibly kill somebody else. That means you had the intention through dolus eventualis to kill somebody else. So the question is not what would a reasonable person have done in the circumstances, is what you actually believed and foresaw. Did you foresee that your actions would kill another person and that you didn't have the justification or the right to do so?
Prof, therein lies the confusion for me as a layperson, because it seems to me, I don't know if I'm correct, it seems to me that the reasons that the judge gave for acquitting him for murder are the same reasons that she gave for finding him guilty on culpable homicide. And that is to say that that space was so small, you should have maybe realized that you would kill that person.
Yes. It's the difference between measuring the person's actions and his or her beliefs against what is reasonable. What would a reasonable person do? In this case, the judge said no reasonable person in Oscar Pistorius' position would truly have believed that his life was in danger, that it was acceptable to shoot into a small cubicle, that you won't actually kill somebody when you do so. So that is why she discussed the matter there. But she said, given all the circumstances, Pistorius didn't act like a reasonable person. He actually truly, really believed that his life was in danger, and that of Riva Steenkamp. He truly believed that he could shoot into the door. He truly believed that he won't kill anyone, and that his actions were reasonable in the circumstances.
Okay.
So this is the difference between what's going on in his head and what should have gone on in his head.
Okay, so shooting 4 times, he really didn't believe that he would kill somebody there.
That's what the judge said. Okay. Whether that is correct, we can discuss it.
Right. So, Lisa, the general sentiment on social media and, you know, the callers to the radio stations and the TV shows has been that, woman, you are on your own now. If you do something to upset your partner, they don't have to do too much to prove that, you know, they didn't intend to kill you, anything like that. Are we fair as South Africans in reading that into this judgment?
No. I mean, to begin with, women have been on their own for ages. This case did not set any kind of precedent and was not new and wasn't particularly unusual if you look at the intimate femicide cases as a whole. I mean, I think what the state tried to do, not very successfully, I think it was because they didn't have a lot of evidence here, was they tried to suggest that far from Pistorius saying, I was protecting, they say, actually, you are the aggressor here. And that was why they were trying to look at the nature of their relationship. Now, it would be very hard to stand up and say with absolute 100% certainty, this was an abusive relationship. The evidence is not really strong enough to sustain that. So while the state, I think, was trying to make an argument that he's an aggressive man, They argued, he didn't like what she said, and so he shot her. It was quite hard to make that sort of argument because the evidence wasn't really there. Yes, we had we had worrying signs in the relationship. We had previous relationships which didn't look too great, but you couldn't really bring those in because the courts would say, you know, from an evidence, the prejudice of that evidence outweighs its probative value. So, and as I said, at no point did the defence ever try and turn around and attack Reeva Steenkamp and suggest she'd asked for it, which is what typically happens. They also didn't try to...
That was a good sign.
Yeah. They also didn't try to suggest that Oscar suffered from strange mental states, which didn't make him responsible, the other tack. Where this case is similar, and in fact did better than I would say those other cases, is the case I talked about where the men beat women to death, because those are also about intent. They argue, I didn't intend to kill her. But the question we always want to ask is, if you hit somebody so hard that you break their ribs, if you kick them, if you hit them on the head with a brick 5 or 6 times, and then still shambok them and set them alight for good measure, what on earth do you think is going to happen but death? But I have yet to see the state ever argue or try to argue dolus eventualis in those cases. Those men rather get charged with assault with intent to cause grievous bodily harm, and those are sentences that carry months, not even years.
And are you saying that the state should argue dolus eventualis in those cases?
I absolutely think
they should. And are they likely
should.
to do so after this case, in your view?
No, not at all. They haven't. I mean, that's where I'd like to see some of the debate starting to happen about what does this tell us about the prosecution of cases generally. I think this case might be perhaps more worrying for general cases where there's shootings, negligence, questions of culpability, but those are not unique or specific to domestic violence. So this case doesn't set new ground, I think, in that area. So I don't think women should feel they've been specifically betrayed by this case. Okay. Those sorts of betrayals have happened long ago, long before, and they will continue to happen because this case didn't fit those sorts of facts.
All right, we have to take another short break, and I just want to ask you quickly, though, that are you saying that generally the judiciary is not amenable to, you know, working with victims of domestic violence?
I think different judges do different things. I've often been called by some judges to be an expert witness to explain domestic violence dynamics and to help them understand the trial. But there have been others where I once testified about marital rape, for example. This was a couple of years ago. The judge laughed in my face. Sure. So you see, you can get different judges thinking different things.
All right. What are your thoughts? Give us those thoughts on Facebook and on Twitter. We are taking another short break, and we wrap up this conversation when we come back. Stay with us. So we are in conversation with Lisa Vetten, who's a research associate at Wits, and Professor Pierre de Vos, who is a constitutional law expert at UCT. And we're talking about the Oscar Pistorius trial and some of your thoughts coming through on Facebook and on Twitter. I'll just pick on one or two others. Nomsa Ndala says, how does pumping 4 bullets into someone not constitute murder with dolus eventualis? And Letulo Marrera says, the fact that he shot 4 times, he had intention to kill, period. And Chris January says, according to the new Arms and Ammunition Controls Act, Oscar Pistorius committed a murder. And those are just some of the ones that we can pick on at this stage. And that last one, Prof, is there now a need to review the gun control aspect, particularly guns owned by private individuals in South Africa? Is there pressure after this case to look into that?
Well, I don't know if there is pressure. I know that over the last few years, the gun control legislation was actually tightened. It so happens that in that same period, the number of murders and the killing of people by guns have actually dropped significantly over the last 5 or 7 years. But my personal view is, of course, that we should have far stricter gun control because guns kill people. If Oscar Pistorius never had a gun, if he only had a baseball bat, nobody would have been killed. So, but I don't know if my view is the majority view in South Africa and whether the politicians will agree with me.
Right.
I do think that it raises interesting and important questions about how dangerous it is when people who are very attached to their guns and a little bit, I can't really say that, but a little, perhaps even a little bit trigger happy, are in possession of guns. It can lead to terrible things happening, as happened in this particular case. Whether you believe the finding of the judge that it was an accident or not, a terrible thing happened, and it happened because a gun was involved.
Your thoughts, Lisa?
I would agree with that. I mean, gosh, I hope I got his name right, but it was the rugby player, Vlees Versace, a couple of years ago, who shot his daughter, also thinking she was an intruder. And some of the research that's been done would suggest that in South Africa, those who own guns are 4 times more likely to have the gun used against them than to actually be able to use the gun in self-defense. So I think guns actually, even if you think it's making you safe, is actually a risk to you. And I think we've certainly seen in intimate femicides that guns, licensed legal firearms, pose a very significant danger to women's lives. The Firearms Control Act has had an effect, but I think there are questions as to why Pistorius and his gun-loving, zombie-stopping habits actually did get a gun. He probably should not have had one. So I think there are questions around how his whole application was dealt with, which could be looked at. And I think that this case should make our firearms officers at police stations and the registrar look very closely at applications in future.
And Prof, what are the other lessons that we can pick up from this case? You know, it was a high-profile case, and like Lisa said, it's not your typical domestic violence case, and you know, there are special circumstances that pertain to this particular case. What can we learn?
Yes, of course, as Lisa said, it's not like any other case. I think for me the interesting thing about the case, which perhaps is not directly related to what happened in the court now, was the effect this televising and broadcasting of the case had on how people engage with the law. I was very struck about the fact that many people who had never before, would never have heard about something like Dolus Eventualis, actually engage with the concept and asked, was it applied correctly or not? Was this really putative self-defense or not? So I think, despite the fact that the outcome of the judgment might not have been in line with what most people expected, I think that the broadcasting of the case actually helped to educate people about the law, to see that the state has to prove its case beyond reasonable doubt, that it's about logic and facts, that it's not only about emotions. So I think on the evidence available, I think that it was probably a good thing that the case was televised and broadcast.
Your thoughts on that one, Lisa, as we wrap up, and also on the performance of the prosecutors in this case, because they usually get most flack. The NPA usually gets a lot of flack when it comes to these cases.
I think they did the best they could from what I can see. And I mean, one of the more interesting outcomes of this case was listening to how many people or students, since I am at Wits, were saying, actually, they think they'd like to be prosecutors. The prosecution has usually been thought of as useless, insipid, and ineffective. But I think people got a very different perspective here. So I think it's good that people want to go and prosecute rather than purely be defense lawyers. That's one that's positive. But I would like to see the media and society more generally not look at this case only as the only example of domestic violence. All right, there might be problems around people performing for cameras, but I'd love to see the courts go and film a typical day in the district court of applying for protection orders, or go into a regional magistrate court and watch how assault GBH cases, which predominantly involve the deaths of poor women, are dealt with, so that people can get a better understanding. Because public pressure is important for changing systems, and we need to change the context more broadly of those cases. One case is not going to do that.
Well, thank you very much. We're going to have to leave it there. Thank you to both my guests for coming through to talk to us, and also to you, Prof, from our Cape Town studios. And like you said earlier, this case has made most of us legal experts. We've got an opinion on what's going on in the judicial system now. And if anything, hopefully, the positive that will come out of that is that more of a spotlight will be shed on the other cases, and more positive results can be reached in those as well. Well, thank you very much to you for joining us on this show. Do join us again next time, as usual. From me, Thembisa Magele, and the team, good night.